Climate Law Matters, the campaigner behind the most significant climate case of this century so far. Interview with Sarah Finch. Hello, listener, and welcome back to our podcast, Climate Law Matters, in which we explore the legal developments across different sectors to address the key issue of climate change. I am Steph David, a barrister at 39 Essex Chambers, specialising in environmental and climate change cases. Today, I am very excited to be joined by Sarah Finch of the Weald Action Group. As I'm sure many of you know, Sarah brought the pivotal judicial route challenge, the decision of Surrey County Council to grant planning permission for oil production at Horse Hill in Surrey. And the Supreme Court handed down its decision earlier this year. Sarah, it's absolutely fantastic you agreed to come on the show. Before we delve into the details of the case, I'm really curious to learn more about you and your campaigning background. What first inspired you to get into campaigning?
Thank you, Steph, very much for inviting me. Well, I've been concerned about the environment as long as I can remember. As a child in the 1970s, I was already raising money for rainforests and worried about acid rain, and the environment has always been my thing. And climate, the first time I actually remember thinking about climate change was in the late 80s. So I worked for the Campaign for Lead-Free Air, campaigning to get lead out of petrol, and that introduced me to the issue of vehicle emissions. And we had discussions about whether we should campaign for catalytic converters to be mandatory on all cars. They remove carbon monoxide and some other pollutants from the exhaust, but they increase emissions of carbon dioxide, so probably worse for the climate. So we had decided against doing that, but that was my first introduction to climate. And after that, I went on to work for Friends of the Earth in the early 90s, where climate was on our radar, though not so much of a priority as it is now. And in 2000, I decided to make climate my main focus, both in my work life and as an activist.
And that's incredible. So you really were ahead of the curve in that sense, weren't you?
I think I was an early adopter of climate anxiety.
And now, Sarah, you're part of the Weald Action Group. And what's the exact focus of your group?
Well, the Weald Action Group is an informal network of individuals and local groups campaigning against onshore oil and gas across the Weald, which is basically Surrey and Sussex, goes into Kent and Hampshire. So in the early 2010s, we were all fighting proposals on different sites and all going through the same learning curve, having to learn about the oil and gas industry, the planning and permitting processes, etc. So we formed this network to share experiences and knowledge and support each other.
And so you said it's a kind of network of individuals. Is that right then?
Yeah, it's not an organisation in any sense. It's just a network of individuals and local groups.
I see. And you said that you got involved when exactly?
Well, the group started in 2016 and I went along to, I think, their first meeting, or one of the first meetings anyway. So I already knew some of the people involved through campaigning against the oil proposal at Bolcombe and Leith Hill and other places, as well as Horse Hill, which was the site nearest to me.
And how did it compare working to a big organisation like Friends of the Earth?
It's completely different because we're all volunteers, we're all doing it in our own time, and we all come at it from different perspectives. So, for example, for many of the people in the Weald Action Group, especially at the beginning, climate wasn't their main issue. They were mostly concerned about the unconventional extraction methods proposed for the southeast. So oil production had been taking place there for decades, but on a small scale using conventional methods. But then now new techniques had become available that made it feasible to extract harder to reach oil deposits. And these techniques are very similar to fracking. And they involve injecting solutions of acid and other chemicals into the ground to fracture the rock. But because of sort of controversy over definitions, it doesn't count as fracking, so it doesn't have the same regulation and it's not subject to the moratorium. And so for a lot of people, that is their sort of main priority, is fighting the methods and trying to get a more comprehensive definition of fracking. And then there are a lot of people whose priority is the local impact, so the heavy tanker traffic involved on the narrow roads and noise and light pollution and local air pollution, etc. And then for me, climate was always my own priority. So we all come at it from different perspectives, but we all have the same goal. And I think climate is becoming more mainstream for everybody now.
That's true. Just then in terms of how your trajectory developed, so you obviously started with emissions and that sort of thing from vehicles and then switched over to fossil fuels. How is it you ended up with that particular focus?
Well, I think everyone knows fossil fuels are probably the main contributor to climate change. So vehicle emissions are fossil fuel emissions ultimately. So I did get involved in trying to stop oil developments, for example, fossil fuel developments. The King's North coal-fired power station was one of the things I campaigned against. And I worked for a while at Greenpeace, particularly on oil and vehicle emissions. But it wasn't a choice that I made. I just happened to be living in a place where an oil site was proposed. So, of course, I was going to oppose that.
And just in terms of the way your network works, I mean, do you link up with other networks nationally or internationally?
We've worked with anti-fracking groups around the country, and we've worked with Friends of the Earth, the national organisation who helped us out with training and advice, but not so much internationally. We did have contact with Justiça Ambiental, which is the Friends of the Earth group in Mozambique. They were fighting a liquid natural gas project for which the UK government has pledged $1.15 billion of export finance. And Friends of the Earth took the government to court over this. And as we were linked by both having campaigns supported by Friends of the Earth, we were in touch with Justiça Ambiental. We organised letter writing to our MPs here about the Mozambique case, and they sent us a message of solidarity to read out at a rally at Horse Hill. But, we're very aware that all over the globe, people are fighting these cases, and we would like to be more in touch, but we haven't really had the capacity to do so.
Sarah, you made a really interesting point earlier about the network's focus on unconventional extraction methods and how that doesn't fit into the definition of fracking and therefore doesn't fall into the moratorium. Can you expand upon that a bit? Just an interesting point.
So for decades, oil's been extracted from the Weald, other parts of England, using conventional methods. But new methods became popular in the 2010s, which involved injecting solutions of acids and other chemicals into the ground to fracture the rock. It's harder to reach oil deposits. And it's similar to fracking, so hydraulic fracturing, but the differences in the volume of fluid used because of the geology being different in our area from, say, parts of the country where fracking is used. They just use a different method. They use acid rather than large volumes of water under pressure to fracture the rock. Other than that, it's the same thing. Acidization is basically fracking with less water. But the definition in the Infrastructure Act of fracking is based on the volume of water used. So the methods that are being used in the southeast, in places like Lincolnshire as well, don't come under that definition. And so they don't have the same regulation as fracking, and they're not subject to the moratorium. So the Weald Action Group is trying to get a more comprehensive definition of fracking accepted so that these other sites would be included. It's all been a big distraction for the campaign because constantly get into discussions about, is it fracking, isn't it fracking? And from my point of view, that's not the only important thing. It's still oil production. It's still getting carbon out of the ground, which is going to be burned and make the climate worse. So it has to be opposed, fracking or not.
What's the current status of that campaign in terms of progress in agreeing the definition?
Well, it's starting up again. I think the Weald Action Group published a report that was some academic article, in fact, that was peer-reviewed and well accepted, making the point that the definition of fracking shouldn't just be about the volume of water used. But then nothing happened, and I think people got exhausted, and we got heavily distracted by the Horse Hill campaign. So there's a working group starting up again, looking at the definition of fracking, which will be trying to get that somehow into law, but I'm not part of that group.
One final question on this topic before we move on to your Supreme Court case. This kind of unconventional extraction method that you describe, which doesn't fall in the definition of fracking, is it associated with the same seismic activity issues that you have with fracking?
Yes, very much so. And actually at Horse Hill, there was a swarm of earthquakes when work restarted there, where there was a whitewash of an inquiry with the Oil and Gas Authority and the British Geological Survey brought together some geologists to look at the question of whether the earthquakes had been started by sort of hydrocarbon activities. And they told these geologists not to look at Horse Hill because they said there was no work happening there at the time, but to look at work at another site, Brockham, nearby. And the geologists came to the conclusion that there was no link between the earthquakes and the activity on that oil site, although even that wasn't the consensus. And then It was later found out that work had been taking place at exactly the time coinciding with the first earthquakes, and we called for that inquiry to be reopened, and it wasn't. So very much a live issue, and we had hoped to include that in the judicial review as well as the climate points, but we found it wasn't going to be arguable legally.
So that brings us nicely then to your Supreme Court case. Just to start with, can you just kind of summarise the facts of the case that you took to the Supreme Court?
Okay, so in September 2019, Surrey County Council approved a proposal for the retention and extension of an existing well site at Horse Hill. It already had 2 wells, and the permission involved keeping them and drilling 4 new oil wells, 1 water reinjection well, and various other infrastructure, and all to enable the production of hydrocarbons from 6 wells for a period of 25 years. And it was anticipated that 3.3 million metric tonnes of crude oil would be produced in this time. And the eventual burning of that could obviously produce more than 10 million tonnes of carbon emissions. But these downstream emissions, so the emissions from actually burning the oil, weren't considered in the environmental impact assessment process. That only looked at the much smaller amount of carbon that would be emitted from the site itself.
I mean, those numbers are quite shocking, aren't they? 10 million tonnes of carbon emissions that hadn't been accounted for in the environmental impact assessment. I mean, that really is something. Can you talk me through the idea behind the case and how you came to bring the challenge?
Well, I opposed this planning application along with many other local residents, parish councils, residents associations, conservation groups, etc. And since the previous 2 wells had been permitted, obviously climate policy had changed. We had the Paris Agreement, national climate targets. Climate was a bigger issue all round. And even Surrey County Council itself had declared a climate emergency not long before the decision took place. So we did have some hope that the committee would turn this down on climate grounds, but that didn't happen. Both the planning officer's report and the debate at the committee didn't deal with the climate impacts in any meaningful way. So we, the Weald Action Group, couldn't accept the decision was right. And we had already had some experience of the law. We'd fought off an aggressive injunction from UK Oil and Gas Limited, the company operating at Horse Hill. So we knew some lawyers, and 2 people, not me, 2 other people, met with a barrister, Mark Willers, QC at the time, now KC, just to discuss what options we would have if the plans were approved. So once planning permission was granted, Mark arranged for us to meet more lawyers, so including barrister Estelle de Hon, now a KC, and solicitors from Lee Day. And then we discussed options with them and decided to call for a judicial review. And they advised us that it was best for an individual to front the case rather than a group, so that we would be able to take advantage of costs protection from the Aarhus Convention. And that's how it ended up being in my name, which is a bit misleading. It's called the Finch case, as if it was all me, but I brought it on behalf of the Weald Action Group, and there was always a group of us behind it.
Well, it sounds like it's a very kind of supportive network of people that you have behind you as part of that Weald Action Group. What then, in your view, is the headline point to take from the case?
We were initially challenging the decision on several grounds, so including earthquakes, as I mentioned, but we realised that some of them were possibly not going anywhere legally. So in the end, the case boiled down to one key point, which was whether it was lawful for Surrey County Council to have made the decision without factoring in the emissions from the use of the oil. So the EIA regulations say that environmental impact assessment should cover all likely significant direct and indirect impacts of the development on the environment, including the climate. And we argued that the downstream emissions were burning the oil were indirect impacts. But the council, the oil company and the government all argued that they weren't, and several judges in the lower courts agreed with them. But in the end, Lord Leggett and the majority of the Supreme Court judges agreed with us. So in the judgment, Lord Leggett says, the only issue is whether the combustion emissions are effects of the project at all. It seems to me plain that they are.
Certainly a very powerful judgment from Lord Leggett. Just to kind of drill into that point a bit further, so how did Lord Leggett approach the question of what an indirect effect is?
The other parties and the other judges had all had reasons why combustion emissions aren't effects of the development. So those include the fact that emissions would occur at another time in another place, that they were outside the control of the developer, that there's an intervening process because the oil would have to be refined before it could be used, and that there are other control regimes that might reduce or avoid the environmental impact. But Lord Leggett dismissed all of these. He talked about causality and what is the cause. And he said, basically, his point was if no oil is extracted, no combustion emissions will occur. Conversely, any extraction of oil by the site operators will in due course result in greenhouse gas emissions upon its inevitable combustion. So he said that the time and the place at which the combustion takes place may not be within the control of the site operators, but that doesn't make any difference. He says those factors are irrelevant to the size and significance of the environmental impact.
I mean, that then brings us to a really important point, doesn't it? Which is in relation to this inevitability of oil that's been extracted then being combusted. Just on that then, so my understanding is there are certain agreed facts before the court. One is in relation to the commercial purposes of the extraction of oil for around 20 years or so. Say that second point is the one we've already mentioned, that it's inevitable that the oil extracted would be ultimately combusted and that it was possible to quantify these emissions. Can you just talk us through how these facts came to be agreed during the course of the litigation?
At the very outset, we agreed a statement of facts and grounds with all the parties. I mean, this was mainly done by the lawyers, so I don't know the details of any negotiations that took place, but it seemed to me that it wasn't difficult to agree, and the first two at least weren't controversial. There may initially have been some difference of opinion about the quantifiability of the emissions. There was some discussion in the High Court about you couldn't expect Surrey County Council to be able to calculate those emissions. However, any doubt on that point was ended in the Court of Appeal hearing because the Council's principal environmental assessment officer submitted a witness statement in which she actually performed this calculation. So she went through their application documents, looking at all of the numbers they gave about the amounts of oil to be produced, and then she used a conversion factor of 3.22 tonnes of carbon dioxide equivalent for every tonne of crude oil produced. And that's a sort of standard assessment that's used in government papers and others. So, I mean, it's basically a simple multiple. If you burn a tonne of oil, you'll get 3.22 tonnes of carbon dioxide. So that then meant that there was not any possible disagreement about the quantifiability.
Which ultimately is a really kind of critical point. Just moving then from the kind of headline point about indirect effects, what other points do you consider the judgment makes?
A key point is that for the EIA regime to function effectively and to make decisions about projects with likely significant environmental effects, these decisions must be subject to public debate. And I think Lord Leggett said they must be made with full knowledge of the environmental cost. And he said that public participation is essential, basically, both to increase the legitimacy of the decisions, but also serving an educational function, so contributing to public awareness about environmental issues. And Lord Leggett said, you can only care about what you know about. So, yeah, a really important vindication of public participation.
Yes, and again, that kind of ties in with the broader principles in the Aarhus Convention as well, doesn't it? So in terms of access to environmental justice and access to environmental information. Sarah, I'm really curious, are there any points, observations or turns of phrase in the judgment that just get you really quite excited?
Well, lots. I mean, overall, I find the judgment really clear and straightforward. And Lord Leggett managed to express a lot of the ideas that we've been arguing all along, but more eloquently. But I think that you can only care about what you know about. It's a very good sort of rallying cry and should be sort of printed out and put in every planning decision maker's office. But he made some very strong statements about climate and about the inevitability of emissions when you produce fossil fuels.
And I probably can guess the answer to this question, but how did you feel on the 20th of June this year when the judgment was handed down?
Oh, it's hard to describe. I felt absolutely overjoyed, hugely relieved. I was walking on air for days, actually. But also in the mix was a little bit of anger that it had taken so long and we'd been through so many hearings and spent so much money over 5 years to get what felt like a statement of the obvious. In fact, that's what Channel 4 News on the 20th of June said. It's a 5-year fight for a statement of the obvious. So just really, I felt very encouraged. I think as a climate campaigner, you get used to basically losing all the time or having to take comfort in very small wins. So to win something as big as that, it was just very motivating, and I've felt energized by it ever since.
I can understand why. I mean, it's absolutely brilliant. And we'll come on to the implications of the decision in our next episode. But one final question for this episode. It was really interesting to see the Supreme Court picked up the Greenpeace Nordic case in their judgment. I mean, were you aware of that case, and what did you think about that?
Yes, I was aware of that case. So that was a case for 3 new offshore oil and gas fields off Norway. And the Norwegian judge in that case found that the consents for those oil fields were invalid because the environmental impact assessments only covered the local emissions and not the emissions from the combustion of the oil and gas. So exactly the same as Horse Hill. So when I saw coverage of that in January, I was struck by the similarity and talked to the lawyers about whether or not we should bring it to the attention of the Supreme Court. I mean, this was after we'd had our hearing, and we didn't want to annoy the judges by kind of submitting more information. We've had our opportunity. And also it was a foreign court and a lower court, so possibly not something to bring to their attention. But we decided to send a brief note. I'm sure they knew about it anyway, but we sent a brief note, and I'm glad that we did.
Thank you very much for your time, Sarah. In our next episode, we'll pick up the implications of the Supreme Court decision. Thank you.